All right, we're going to go ahead and get started. For those of you who don't know me, my name is Jocelyn King. I'm the CEO and founder of Virtual HR. Virtual HR is an employment and labor law compliance tool for you to use. So if you as an HR practitioner are getting certain tasks like a leave request or termination, or you're onboarding somebody and you need to know what the federal, state, and local employment and labor laws are that apply to that specific employee, rather than spending time on Google or going to a lawyer, you can instead use our software, and our software analyzes what federal, state, and local employment and labor laws apply to that specific employee, and then provides prescriptive legal guidance to you. We have a lot of other features to our tool as well, including an employee handbook builder where you can create new handbooks or upload existing handbooks. And our software analyzes what policies are missing so that you have the most up-to-date handbook possible. We also have legal updates, the ability to speak to a labor and employment attorney if you wanted to, tons of resources, and a multi-state comparison tool as well. So if you're interested in learning more, we will have a QR code at the very end for you to schedule a demo. And I'd love to meet and show you more about our platform. I'll pass it off to Laura.
Hi, welcome everybody. Thanks for joining us today. My name is Laura Donahoe. I've been in HR for about 20 plus years, and I have actually created an online virtual HR community across the United States for HR professionals to network, connect, get to know each other, ask questions, vent, share resources, tools, all kinds of fun stuff. It's a very robust platform, and it's a great opportunity to get to network and meet people. So hopefully you can check us out at elitehrconnections.com.
Thank you. And Christine?
Thank you. Hi, everybody. Welcome. Glad you're here. My name is Christine Walters. I'm an independent HR and employment law consultant. So spent about 10 years in in-house HR administration, practiced employment law with the law firm for a couple of years. And in 2002, then went out on my own, and I have my own practice, 5L company, doing HR and employment law consulting.
Oh, great. All right, awesome. Well, this is, I don't know if it's an exciting topic, but I find it to be a really exciting topic actually, because this is changing all the time. And it looks like maybe this might go through. We'll see. We've got another week and a half or so. It's looking like it's happening, right, Christine?
Well, that was going to be one of my comments. The court, so there's two legal challenges, one both in Texas. One court, last I read, don't quote me on this, was scheduled to hear oral arguments on the 24th, which is next week. So I think everybody kind of remembers what happened in 2016, 17, right? 5 days before the rule was to go into effect, it was blocked. So I don't have a crystal ball. I'm betting it's going to get blocked again. We'll
And
see.
this is the same court too, right?
I believe at least one of the suits is in the same court. Yes. And they both might be.
Yeah, interesting. Yeah, and actually I should add this disclaimer because Christine is an attorney. Everything in this webinar today is for informational purposes only. Please don't construe it as legal advice. We would still ask that you seek legal counsel before you make any actions or decisions. This is for informational purposes only. Hate doing those disclaimers, but they're still really important. Perfect. So I'm going to go ahead and jump in then. And I hope you all will kind of entertain me as I'm trying out this new presentation tool. It's called Prezi. So would love any feedback. If it gives people headaches or they love it, whatever, please let me know. But as we know, the Department of Labor has announced this new overtime rule. There are challenges to it. There are opportunities as well. The opportunity, of course, is enhancing employee welfare. And that kind of leaves us as HR practitioners with two options, whether we reclassify employees or increase pay if they're kind of coming close to that threshold. So a few things here right now. Currently, the threshold is $684 a week, or about $35,000 a year. Starting July 1st, just as a refresher for any of those who aren't aware, the proposed increase is $844 a week, or around $43,000 a year. And then it actually increases January 1st of 25 to $1,128 a week, or roughly at $58,000 a year. There are also some changes to the salary threshold for highly compensated employees, which would set to increase to 132,000-ish per year starting July 1st, and then another increase January 1st of 151,000. So What's really important and key here is reviewing your job duties, your job descriptions, taking a look at your salary levels and potentially revising them, and then thinking from a business decision. And from business decision, a couple of different areas. There's the finance aspect, and then there's the employee well-being aspect. Does it make sense to reclassify or increase pay? So before I continue, one question that I had for you, Christine, is, are there any exceptions or special provisions to the new rule that we should be aware of?
None that don't already exist. So all this really did was modify the regulatory portion of the Fair Labor Standards Act. And it was just one of the three tests: minimum salary test, salary basis and duties tests. And so all this has done is modify the minimum salary threshold.
Mhm. Yeah, great.
I guess I'll throw in, again, not a change. If anybody used, so you might remember we had that 10% exception rule. So to meet the minimum salary threshold, for example, today, if an employee made 90%, so if their guaranteed minimum salary was 90% of 684, that could be an exception. They could still be classified as exempt, but then you have to make sure they get a non-discretionary bonus to make up at least that 10% differential within the year in which you're measuring the wages or the salary.
From an administrator perspective, that sounds like such a horrific thing to have to go through.
I don't know, and I'd love if anybody's using that 10% rule and you want to like raise your hand or give us a cup of coffee or sunglasses or something.
Mhm.
I don't know anybody that still has. I came across a few employers that tried it. I don't think I've come across anybody that tried it and kept it.
Okay. And speaking of which, we do have a Q&A session at the end, so please use the Q&A function in Zoom rather than chat to send your questions, and we'll cover those at the very end of the webinar.
Thank you.
But yeah, any sunglasses or coffee emojis can go in the regular chat function. That's fine. Okay, perfect. So there are some considerations that need to be made in this situation. The first, and I talked about a little earlier, is cost, right? The finances. How does that impact your budget overall? Considerations, of course, how are you staying compliant? And then the third piece is employee morale. I think that there are a lot of employees out there that if they were reclassified from exempt to non-exempt, that might make them feel like, I don't know, like a secondary citizen or something like that, right? They have their kind of own perceptions about it. So those are considerations that need to be made. And ultimately, in preparing for this, the three goals are ensuring, of course, that there's a smooth transition, all the while doing so remaining compliant, which can be tough when things get a little tricky. Like Christine, I've been in HR for 15 years and I hadn't even heard of the 10% rule. That's not my bag. So I hadn't even heard of that. So remaining compliant is key. And then employee communication. This is like everything else in HR, it's all about change management. How are you communicating with your team members? How are they feeling valued? Do they understand what's expected of them? Especially, for example, someone's going from exempt to non-exempt and they now have to take meal and rest breaks, for example, or actually track their hours. Are they getting the training that they need in order to be successful? So I do actually think it's kind of interesting to just point out SHRM's view on this. There were quite a few organizations that were not thrilled with how this has turned out. In general, of course, SHRM thinks that it's a good idea to increase the threshold, but the considerable leap is something that's really concerning. And so it's just something for us as HR practitioners to really think about if we want to be proactive or have our voice heard in some way, whether that's getting involved with SHRM, your SHRM chapters, or any other organization, just thinking about what other think tanks or those who are influencing policy are saying about this. This is something that maybe potentially might just be a little too high since the increase is a bit steep. But we're going to talk a little bit about why this is so important, and I'm sure it goes without saying, but it was so easy for me to find this. Literally, I asked ChatGPT and it gave me like 50 different examples, and that's where I got this from. But Dollar General agreed to pay $8.5 million to settle class action lawsuit involving the misclassification of store workers. And Wells Fargo agreed to a $3 million settlement for similar misclassification case involving home mortgage consultants. Those are big companies, but absolutely nobody is immune to getting in trouble for misclassification. Every 1 in 10 employers each year is sued for a number of reasons, and the small companies get sued, with enough frequency that any company of any size should be concerned. The other thing to really take into account is the fact that not only are these laws changing at a federal level, and it's possible this might not even end up going through July 1, but there are also state and local considerations that you need to make as well. Maine's just come out, they're increasing their salary threshold that will go well above the federal proposal that we have out right now. So it's important to kind of keep up with all of these state and local requirements too. I'm wondering, Christine, just in your experience, how would we handle employees who are currently exempt, who now fall below the new salary threshold? What would you recommend the steps HR take?
First is, I think, communicate. And so, because we don't know for sure what's going to happen, and I think most everybody has, but absolutely start the conversation with your employees who are currently classified as exempt and make below, so this is their guaranteed weekly salary, minimum weekly salary, make below the proposed new threshold. Just let them know, hey, we don't know what's going to happen. There is potential that effective July 1st, how you're compensated may change. And so what would that look like? We have options, and options are great. So we could, title of the program, we could just reclassify. Here's, your annual salary is 100,000 today. We're going to divide it by 2080 hours, assuming you're full-time, and that's your hourly rate. And now you're going to get paid on an hourly basis, and you get overtime for every hour worked over 40 in a work week. Option 1. Option 2, we're going to keep you properly classified as exempt, and we're going to increase your base salary so it meets the new threshold. Challenging because of wage compression, right? If you bump me up, then the person who was paid just a little bit more than me might be the same or less. So we might have to bump up the row. A third option is, rather than just converting the exempt employee's current salary to an hourly rate, knowing they're going to earn overtime. And honestly, you can look up on the internet overtime conversion calculators or something like that. There's plenty of them out there. Then there's a formula we can use, and you just estimate about how many overtime hours do you think this exempt employee worked last year. And you use that number to calculate the new hourly rate that will, because we know they're going to get overtime, time and a half for all the hours worked over 40. And this calculator will convert that so that their total compensation at the end of the next year should be just about exactly the same as what they earned last year, despite the fact that they're earning overtime. So those are at least 3 options out there for us.
Yeah, I think, and we'll cover this a little bit in here. Sorry, I'm playing around with this now because I'm still figuring it out myself, the financial implications that we're kind of talking to. So you need to really think about the financial implications of reclassifying or the pay increase, right? So doing kind of a pay audit across your organization might be a really helpful way of determining whether or not it does in fact make sense. Maybe this is a good time to do some pay increases because you haven't benchmarked in a while and you're due for pay increases and you can budget that in. But as Christine mentioned, there may be times when if you increase someone else's pay, they might get too close to maybe the top of the salary of a pay scale, for example. And that kind of puts them in a position where it would be difficult to give them a future pay increase. It's really hard for employees to understand that justification, of course, or accept it at least. But on the flip side, if you're reclassifying and they now qualify for overtime, you have to take that cost into account as well. And so, not to mention the fact that there's impact to like benefits and bonuses and And so a lot of financial implications here that it would behoove you to really connect with your head of finance if you haven't done so already, and really start breaking down some scenarios to figure out what's going to make sense for your organization. Is it a matter of the pay increase? Is it a matter of reclassifying? What does that cost actually look like on both ends? And then keeping in mind, of course, that we have this increase that's set to go into effect July 1. Then we also have another one that goes into effect January 1. So do you increase to the January threshold so that you don't have to do it twice? Do you just decide, hey, every time this happens, I'm just going to keep looking at increasing or deciding whether I want to reclassify again at that point? There's a lot to think about, and unfortunately, not a ton of time with July 1 coming up, but there potentially being a delay could give others opportunity to really perform a thoughtful exercise with their finance team to see what makes sense. Laura, in your experience as an HR consultant, having worked with a lot of organizations, in your opinion, what are the potential financial impacts of the new overtime rule on a business?
It's funny you ask this now. I actually had this conversation yesterday with an employer. This is the exact conversation because we have an employee, well, a couple of them, but one in particular, and we were trying to figure out what is the best strategy for, number one, not being hasty, because I know sometimes that these plans you put in place may need to change because the ruling changes as of whatever date, even up to the date. So we're just trying to figure out and talking with the leadership and putting a strategy together to figure out, does it make sense to increase that person's wage from an hourly perspective? Do we just increase it based on what it's going to be, like you mentioned, in coming up in July, or do we base it what's coming up in January? You also have to consider some of these are that I work with, at least in this DC metro area, are federal contractors, and they have to bill a certain rate. So throw that into the mix. It's an interesting scenario. And sometimes they're not even able to bill at that increased rate, and they have to go back to the government and ask for it. Or even if it's not the government, it could be a different client. So thinking about all of this from a strategic viewpoint is critical. So I was meeting with the leadership, the CFO, all of them in one place at one time because everybody was throwing out these different scenarios. And then what you want to think about is, like you guys have mentioned before, what's the cost of doing that? Does it make sense to increase it across the board anyway? And honestly, one of the major considerations that we talked about yesterday was, what's the impact on the employee morale and their retention? Is this going to upset them in any way? Obviously, if you increase it, it generally is going to make employees happy. But it's not always that simple. A lot goes into employee morale. So thinking about it from those types of perspectives is really important, and having that conversation between all the key players is critical.
Yeah, absolutely. You know, I was thinking a little bit just about risk and audits. My favorite thing to think about. And Christine, it made me think, like, is there any documentation required to demonstrate that you're in compliance with this new rule?
I'm not aware of any that's required. I think there's definitely at least proactive or recommended practices. And thanks again for the disclaimer, because I'm about to kind of half repeat it. And that is, talk to your company's legal counsel. Because, the risk of we want to be proactive and audit everything that we do periodically. The trick is, if you conduct an audit and you find an oops and you don't fix it, or you try to fix it, but maybe you didn't get it quite right, all that, the audit, all your findings, everything's discoverable. So you might, if you use legal counsel, talk to your legal counsel about, should we conduct an audit? Yes or no, whether the rule goes into effect or not. And if yes, may we do it under legal counsel's direction and control? And that will protect, under attorney-client privilege, all that documentation, your findings, your recommendations, that kind of thing. Not because we want to hide anything, but we also don't want what we find spun. oh, well, you knew this. Well, wait a minute. You don't know what the whole conversation was. Um, so I think having, and then that conversation aside, documentation wise, just like a little HR audit check sheet or checklist so that for every, and we want to remember, we have to do this by the person, not the job, right? Because I could have 5 incumbents with the same job title. 4 might be properly classified as exempt, but one's not because they're part-time and they don't meet the minimum salary, or they're, kind of a poor performer, so that they're not regularly exercising discretion, independent judgment. But I think if you just have a little audit checklist that says, minimum salary, salary basis, do they meet the duties test under administrative, professional, executive, and you just have an audit sheet for every person that you audited, and then maybe you summarize your findings on an Excel spreadsheet. Christine, Jocelyn, Laura, currently exempt, still exempt, yes or no, why or why not? And then, demonstrate good faith and due diligence. I think you're 80% of the way there, even
Yeah.
if you get it wrong.
Yeah, that's great. Great advice. Thank you. All right. So a little bit on the budget side, just to kind of like account for these adjustments and associated costs. I don't want to beat this with a dead horse. So I'm going to kind of move on from this and just say like, as you are working on this with your finance team and any other stakeholders that are involved in this exercise, also please consider the threshold increase timeline. Because if you're working on your 25 budget, you've got to start thinking about that now. Okay, training and support. So one piece that I kind of put in here actually was just like HR having an understanding of a proper classification audit. Christine's been an attorney for a couple businesses that I've worked for in the past, and I would always have to source all the classification audits to Christine because they were really complicated and doing it state to state was tough. We had a lot of roles that were on the cusp of being exempt or non-exempt as well, so it was really tricky. Just being educated yourself as an HR practitioner on a proper classification audit is really key. I will just note really quickly, we do have a classification audit tool to determine whether an individual should be exempt or non-exempt, or an independent contractor versus an employee. It's a really great tool for, especially those who are not very familiar with the process, but I would definitely encourage you to orient yourself more on that. In terms of training and support, training managers on overtime and meal and rest break laws. They need to be well aware of what those are, and keep in mind, of course, that there are the federal levels, but then there's also the state. I don't know if there are any specific local meal and rest break laws. There might be, but you want to orient yourself on those as well. So putting a training together for them on that, if you are going to be reclassifying individuals into a non-exempt role, is really critical. And then also not in here, I actually think I have it a little later on in the deck, but just training your employees who are being impacted as well on how they need to comply. And the consequences of not being in compliance too. So my very first job in HR, I worked for Target, and we were in Maryland. So we went by the 6-hour rule. So people would take their breaks at 5.5 hours in. And as a manager, you had this kind of like device that you carried around with you. And anytime somebody was getting close to that 5.5 hour mark, it would just scream at you. I mean, they didn't play around. They had a whole system set up to make sure that everybody was taking their breaks when they were supposed to. It was a very vocal tool that they used for us, but it worked really well. And then I'd also recommend creating an internal policy on handling classification audits as well. There should be some type of cadence to doing this and ensuring that you're keeping up with all the changes that are occurring at the federal level, but also at the state level as well. Anything that I didn't add here that the two of you would like to comment on?
No, I think they were all good points, including training HR, because we don't want to assume, HR is doing everything.
Yeah.
A carrot to dangle, because sometimes we have training, and even if we call it mandatory, not everybody comes, is reminding managers that the Fair Labor Standards Act includes individual liability, and that if a manager messes up, like is making deductions on the pay sheet, or they can be sued as an individual. And so help us help you come to the training, and that might entice more people to show up than not.
That's a really great point. Yeah. Actually, just looking at policies here, do you have any recommendations on whether or not people should be updating any policies in their handbook as a result of this new rule?
I thought I would share. I'm not sure because of this rule, but if everybody didn't catch it, and I'll actually say a nice thing about COVID-19. So, COVID hits, so many more people work from home, and the US Department of Labor came out with a reminder, and some courts had already said this, is if you have a very clear, plain, well-written procedure for timekeeping, what's the process employees, non-exempt employees are supposed to follow to record their hours worked? And your employee fails to follow that procedure, and then they sue you for back wages for hours that they worked but weren't paid, that employee might not win because they didn't follow your procedure. You can't pay for what you don't know, and you shouldn't reasonably have known that they worked because they didn't follow your procedure. So if you haven't looked at your timekeeping policy, including the procedure lately, I'd say give that a peek. Make sure it's plain language, very clear, and that can be a winner for you.
Yeah, absolutely. And if you just don't have any non-exempt employees on staff now and you're about to reclassify, there are some additional policies you'll have to incorporate into your handbook as a result of that change as well,
Good
including
point.
the overtime policy. Because if I'm not mistaken, you can certainly say, hey, you can't go over 40 hours without permission. Granted, if they did, you'd still have to pay it, the overtime, right?
Perfect. You still have to pay it, and not to be mean, but help us help you. We're going to have to issue corrective action because when you don't follow that rule, we can get in trouble. That's how important it is.
Yeah. Yeah, great. Employee support. So I think it might be really helpful if you, as an HR team, put together an FAQ for your employees who are being impacted, just as like the preliminary step. But speaking to each one individually who's going to be impacted in a positive or negative way is obviously really key. If you're reclassifying an individual to non-exempt, there are great benefits behind being non-exempt. That's why this law is passing, is because it's supposed to be in the best interest of the employee. So really explaining what those benefits are, and then also maybe gently reminding them that if they're unhappy, this is a federal law change. A lot of people assume that it's a company decision. It happens all the time. Oh, why'd you change this leave policy? Well, I didn't. It's a law, right? So they assume that quite often. So explaining that can be really helpful in that change process too. If for whatever reason someone's salary were to decrease for whatever reason in this process, which we really shouldn't see much of, but if it did, just come prepared explaining why. And then, of course, as I mentioned earlier, training them on these different rules, the policies, making sure you get acknowledgement that they've received these policies, et cetera, is also going to be really key. Putting together that checklist of what you need to do in order to be well prepared for this implementation is important. And these are huge aspects of it, the employee support side of things. So timeline and implementation. July 1st is rapidly approaching, of course. Consider just taking a look at your salary levels for now and determining once you've done so who or which people might be impacted by their roles. If they kind of fall close to that threshold, you'll want to do a classification audit to just determine whether or not they are truly an exempt employee or whether they're more defined as non-exempt based on the new rule. Meet with your finance team, of course, and then administer the classification, the pay change. And then again, think about how often do you want to do this? Do you want to do it again in January? Do you want to be preemptive now? What if it ends up delaying or it doesn't go through and then you've increased somebody's pay thinking about January threshold? It's a mess right now, but we're here to work with you. So I think that's it. I'll pass it off to, I'm sorry, monitoring progress, just tracking feedback and compliance as well. So track and make sure, are they being compliant with their meal and rest break? Are they being compliant with your policy when it comes to tracking time, for example? That's going to be really critical. And then just, of course, maintaining the minimum wage requirements at the federal, state, and local level. Those are constantly changing. And then future plans for increases, of course. So I'm going to pass it off now for questions. We have a few that have come in. I'll start off with the first one. This is from April. Thank you. She's asking salespeople, if they're paid via draws against commissions, is this form of compensation subject to the same FLSA minimum pay for overtime exemption as salary is? Do you know the answer to that, Christine?
So I was going to say, is this a me question?
Yeah, I think so.
So we have inside sales and outside sales. To be properly classified as exempt, the person has to be outside sales. If they're in a call center, if they're not on the road making sales, visiting sites, whatever, more than 50% of the time on average, they have to be non-exempt. So I would start with that analysis. Then if they are truly outside sales, draw. So I've seen draw against commission work a couple of different ways. The trick would be so here's my base commission. Let's say let's just say it's 700 a week today. So meets the minimum salary threshold, but in the work weeks or the monthly equivalent where I don't meet my sales quota, if you're going to draw against my commission and that draw means I not take home, but my total weekly salary for that work week is going to be less than 684 because you took the drew out of my base commission, that's not going to meet the minimum salary. So we have the minimum salary test, and then we have the salary basis test, which is the rule that says we don't deduct for quality or quantity, same wages every week, regardless of hours worked. That's my language, not in the regulations. So a little funky, not a direct answer, but a couple of a little bit of food for thought, maybe.
Yep. Candace asked if this is going to be recorded. Yes, we'll be sending it out early next week to everybody who attended so that they can have a recording of this. And she also asked if this does go through on July 1st, how long will organizations have to get in compliance? And I'm pretty sure the answer is July 1st, if I'm not mistaken, Christine.
I think so, and that's a good. Sometimes the Department of Labor will say it's effective July 1st, but we're not going to enforce it for like 90 days.
Mhm.
I don't remember seeing that, so I'm not going to say it's not in the proposed rule. Jocelyn, if you want me to take a peek and I can send you the answer and folks can reach out to you afterwards, I don't mind doing that.
Sure, thank you.
Mm-hmm.
Somebody asked, you said we have a classification tool. Where can I find that tool? If you are a customer of Virtual HR's, you go to the chatbot, and in the chatbot screen, you can choose employee classification or worker classification. You'll choose the state that the employee is in, and then it will take you through that whole audit. But if you have any issues, like, feel free to reach out to me directly and I can walk you through it. Next question. I'm in California, which is above and beyond many other states. We have salaries above the minimum for exempt level, which is higher in California than the federal. I'm curious about the administration exemption. I've been in HR for a long time, but I'm still blurry on what roles, job duties, responsibilities qualify for the admin exemption. This is for positions that do not supervise, do not hire or fire, do not run a department and or function for the company.
Laura, you want to take that one?
So I'll lean on you a little bit, maybe if I speak out of turn, but I would definitely say that it's important to follow the threshold that you are living in. So if it's the California, make sure you're staying within that exemption rate. Now, for the administrative exemption, I believe, and I haven't looked at this recently, it has been a while since I've reclassified an administratively exempt employee, but I do believe that this in particular isn't affecting, this regulation isn't affecting the exempt duties test. So that would have stayed the same. And I would have to pull up what all those are, but I believe making decisions that are business have an impact on the business is one of the critical factors in that duties test. So being in HR, a lot of what we do can have a significant business impact if we're making those types of decisions. Now, it doesn't mean that that leadership wouldn't have the final say or something along those lines, but sometimes we do need to act fast, and that would be a requirement. Please feel free to jump in, because I know I missed a couple of the admin duties, but that would be a key one that I recall.
Yeah, no, you're good. So it's kind of three things. So they have to perform office or non-manual work. That's pretty easy. They're not like labor, working out in fields or anything. And they regularly, more than 50% of the time on average, exercise discretion and independent judgment with respect to matters of significance. And the regulations, I think, do a good job, very much like what Laura described, where I don't like I think administrative exemption is misleading, just that term. It could be an administrative assistant, but not necessarily. So I think in terms of someone who is administering your business operations, they're creating policies, procedures, their discretion, independent judgment. They're making decisions about purchasing, selling, signing contracts. And sometimes I hear employees say, "Oh, well, I make decisions with respect to matters of significance." Great. Give me an example. I take my breaks whenever I want. I take lunch whenever I want. I can come in early and leave late so long as those, respectfully, the Department of Labor doesn't consider those matters of significance. They really have to impact your business operations. And I love the regulations because they give HR professionals, as an example, those who are creating, administering policies like employment policies and advising managers about those policies and how to implement them.
I think this might be a follow-on question to it. If we decide not to reclassify and keep jobs exempt, we have to pay the overtime. If they work above and beyond 40 hours a week, this is for those meeting the administrative exemption. I'm not sure if I understood that question. If they meet the administrative exemption, then they would remain exempt and there would be no overtime.
Yeah, that's what I'm thinking. If they meet the minimum salary basis test. Yeah. And let me throw in one other thing. I should backpedal a little bit. And Jocelyn said it a couple times. I cannot emphasize it enough. There are at least 12 or 13 states that do have their own rules. And you mentioned California. California's not alone. And these state rules are stricter than the federal. And so Virtual HR's tool, fabulous tool to have, so you don't have to, like, where do I find the regulations? Who wants to read them? Like, that's no fun. So great tool there. And some states, it's not just the minimum salary basis or salary minimum level that some states have that's higher than a federal. Some have a different duties test. And I'm kind of thinking, I think California, you have a percentage and it has to be more than 50%. Now, the federal regulations say it has to be, the person's regular duty. So there's an inference of more than 50%, but I'm pretty sure California actually put it in there. So when it gets to a challenge, you're going to be looking up how many hours did they work? How many hours did they do this, do that, that kind of thing. So just all in all, good points. But yes, Jocelyn, I agree. If they meet the minimum salary and the duties and all that good stuff, don't have to pay them overtime.
Yep. Next question. At our organization, we do not have any exempt managers. We do not have any exempt managers maybe who fall into the July 1st, 2024 category, and with an annual 3% increase effective July 1. As a result, we only have one management staff will earn slightly lower than $1,128 a week. Can we just do a salary adjustment / market adjustment for this case? Yes, I think absolutely.
That's what I would recommend doing.
Yeah.
And I would even do some salary research just to make sure that that position is following within that range of where you're located and is adequate for that type of work and job. So it doesn't hurt to do that. And I would also recommend taking them up to that rate that is required, and having the discussion with them about why it might be a little bit more than the average, or like I believe it was Christine that mentioned earlier, just opening the communication up with them for them to understand why this is happening.
Mhm.
I'm just curious, did they say they don't have any exempt managers?
Yes.
So they're all non-exempt.
Uh-huh. Yeah, yes, I'm a little confused about the question.
Yeah,
I'm
so you
sorry.
don't have to do
Uh,
anything, but you certainly could. They'd like a pay raise, I bet.
Yeah, Susan, you may want to re-clarify if they are all non-exempt as is, then you wouldn't need to do a salary adjustment. It would just be to get them to an exempt status. Please feel free to rewrite that if you'd like to. Oh, she says they are exempt managers. Okay.
Oh, okay.
Yeah.
Okay.
Then if that's the case, I think a salary adjustment to get that one individual to the threshold works great. Okay, last question is, we have field marketer roles that earn $40,000 plus variable pay. Setting aside potential misclassification, would the best strategy be to increase salary to a new rate? Otherwise, wouldn't we be supplementing salary for any months that there isn't variable pay sufficient to meet the threshold? Number two, based on Christine's comment, our outside sales team moved to virtual during COVID. They still largely operate this way. Does this fail exemption test?
Second one, sounds easier. So the second one, no, if if they're out in the field making sales calls, I think that would qualify. If they're making sales from their home office, I would talk to your company's legal counsel. For me, that would be the same as a call center. But if they're out and about, going to this prospective client's business site, work site, the regulations are pretty clear about they need to be on the road visiting locations for the purpose of making sales. So yeah, maybe you can also just use any search engine and look up DOL opinion letters or DOL FLSA opinion letters. You'll get right to the DOL's website, and you can kind of do some searches as well for like outside sales and that kind of thing.
Mhm. Great. And then to the first question about them
Oh, yeah.
earning 40K plus variable pay. I'm not familiar with this. How does variable pay play into that salary level that they have to be at?
So maybe the writer can clarify. One thing I heard that concerned me, not concerned me, that perked up my ears, was I heard monthly pay. Another really, really important. I just had this conversation at happy hour with some friends last evening, and we were talking about, do you think the rule is going to take effect? Yes or no? And I was saying the 684 and the 800 and the 1128 numbers, and my colleague was saying completely different numbers. And I was like freaking out, like, when did they change? What did I miss? And realized she was talking about the salary, annual salary to be exempt, and I was talking about weekly. And that's where some employers get in trouble sometimes, is they're using a monthly or annual equivalent. And to properly be exempt, the employee has to, that guaranteed minimum salary has to be at least 684 a week, aside from that 90% exempt exception. So if you're taking that and the 684 and turning it into a monthly amount, and then making up a difference where there's a deficit, just proceed with caution and make sure that monthly is still providing at least today 684 a week.
Yeah, because if it doesn't, they're gonna have to closely monitor that, because if it doesn't, they'd have to very quickly make some adjustments. It sounds like if the field marketer role would be a non-exempt role. So there would have to be some salary adjustments made if they, well, no, would there have to be salary adjustments made if they stay as non-exempt?
I don't know,
No.
so up internal equity, not
Yeah.
for this rule.
Yeah. Okay, great. Oh, those are all the questions that we have.